I'm sorry, Counsel. I'm all the confusion. I'm not sure if you heard my question. Did you have a verified?
Sorry, I didn't
did you have a
my
verified?
response. I have no comment. Thank you.
We're on location here in Nashua, New Hampshire, with Jeannie Ingress and Sean Masterson, the counsel for Sheckman, Halpern, and Savage, indicated during the court hearing that. Well, tell us what he indicated during the court hearing regarding the wet ink note.
Well, he said that he verified that he had looked in his drawer and that he found it, lo and behold, the wet ink original signature note and mortgage, to which I objected as hearsay because, first of all, there was no bank officer in the court and he was just the lawyer representing them, so he had no proof, nothing else. He just told the judge, yeah, I have it, don't worry about it, it's all cool, so give me the house, baby.
That's basically what he says. And then not only is the problem that even if he did happen to have the wet ink note in his drawer, which he shouldn't have there, but even if he had it there, it does not go to the point of whether or not there's a verified chain of custody of that note.
Hello, Counsel. Chris King, kingcast.net. How are you?
Thank you.
Okay. Can you tell us what just happened here? Basically, you're scheduling out the balance of the proceedings in the case?
I have no comment. Thank you.
Okay. Just one quick question, though. Do you have a verified chain of custody for the wet ink note or the mortgage? Sir?
Do you have any questions?
There's nothing for me to sign because I have no attorney, is that correct?
You can sign it for yourself. You'd be representing yourself.
So, not as attorney.
So you could put your name. Just put it.
So now
We take it back into the court and give it to both the cops.
I'm sorry, Counsel. I'm all the confusion. I'm not sure if you heard my question. Did you have a verified?
Sorry, I didn't
did you have a
my
verified?
response. I have no comment. Thank you.
Oh, so you won't answer whether or not there's a verified chain of custody for the note or anything? Okay.
So we don't forget.
I did already.
Oh, you did. And you have the Foreman, Ingress versus Wells Fargo?
Dispute resolution is mandatory in New Hampshire. Whether you think you can settle it through it or not, you're required to go and make a good faith effort to settle it. In particular, this case, I think, is a case where I think a mediator can help define the issues if it goes forward. We have a foreclosure mediation program, and I'm going to assign you to that program and expect you to go.
Is there a choice in this matter?
Yeah, no, there's no choice. It's mandatory. Okay?
And so you will make that sign?
Yes, I'm going to assign a mediator to you. I'm going to send you, you'll get the paperwork about the mediation program for foreclosures, and I have to do that before the trial. Okay? All right.
Your Honor, if I may, is it possible to get a copy of that for ourselves?
Yes.
Yeah, can we form that just
For both?
if not today, Your Honor, we can get a copy of it.
Well, you will get a copy of it.
We will get a copy. That's fine.
It will be mailed.
That's fine.
Unless you have a need immediately for it.
Set it on my calendar.
So, thank you.
Thank you.
Ms. Ingress, what just happened in that courtroom?
Well, we had a conference at the judge's podium with the lawyer representing Wells Fargo.
And his name is?
His name is Sean Masterson from Sheckman, Halpern, Savage, LLP.
Okay.
And they had put in a motion for a counterclaim against me, and I had put in a motion to dismiss counterclaim. And the timing in between the various actions was such that the first hearing, they were in default, and the judge put them in default in her notice of decision because they didn't show up. So then they came up with a counterclaim more than 10 days later, more than 21 days later, more than 30 days later. So it was after the time that they would have had to appeal that for a hearing, to get a hearing to nullify the default.
Okay.
However, I'm maybe not saying to vacate the default judgment is how I should say that, I guess.
Okay.
So there were two reasons why I went for a dismissal of the counterclaim. They had something against me, which I corrected the record and fixed the mistakes that I had made. I had two mistakes.
Well, let's back up a minute. What are they claiming? What's the counterclaim? What are they seeking?
They're seeking to foreclose on the house and take the property and keep the wedding signature note and mortgage and all derivatives. So my feeling about this whole thing is that they want both issues. Whereas if there's two parties and there's two things at stake, one is the real property and one is the wedding signature note and mortgage plus all derivatives that come from the securitization of the paper. So no one party can have both of those things, and they're trying to get both things. They want to kick me out of the house plus keep the paper. So my position is take the property if you feel that you have the standing and can prove the chain of assignments and the validity and have it verified. But if you do that, then I need to have the paper, and the court needs to have it sequestered into evidence so that the wedding signature note and mortgage cannot float around where they're still selling my name associated with this property.
Did you have any legal support for that today? I thought the judge asked you at one point for some legal authority for your position.
She asked me where I came up with all of this from, and I said, well, we had this case that I was presenting with my motion to dismiss.
And what case is that?
This is the case of, I'm not sure if I say this correctly, Miroslav Zesevec, who's versus U.S. Bank National Association as trustee, Harmon Law Offices, PC, Mortgage Lenders Network USA, Lenders Network, Wells Fargo Bank N.A., DBA America's Servicing Company, and GMAC.
Where's that case out of?
Belknap Superior Court in New Hampshire.
What case number is it for people out there?
Docket number 10E196. And I can give you this to photograph.
And I believe I have that case on
I believe you sent that case to me.
I believe I put it on the internet at mortgagemovies.blogspot.com.
Right, and this case has a few things in it that are relevant to my case as well.
Very well. I understand your position. The counselor did not want to speak to me, so I had to get a little. Let's back up. Okay. Open it again. Open it again.
I'll go to this case.
Hold on. Stay right there. Okay. Well, thank you very much. I understand that your position now, and the counselor did not want to, speak to me. We got that on video earlier, but I do appreciate your candor.
One of the other things was that I was trying, when we were filling out the question,
yes,
the dates, I was trying to say that we didn't want to have an alternate mediation of some sort.
Yes.
And an alternate dispute resolution, it's called.
Yes.
But she said that that is mandatory and that we have to go for mediation. So somewhere in there, and hopefully we'll get the sequence, the chronology of when everything has to happen. So.
Okay. Well, I look forward to following the case.
90 days.
Yes, I look forward to following the case.
Well, I hope you do.
Indeed. Thank you.
Thank you. Appreciate your work.
Stay right there. Stay right there. Don't move.